All rise. The Court of Appeal and for the 5th District is now in session. The Honorable David A. Monaco, Chief Judge presiding. All persons having business before this court, draw your big attention and you shall be heard. May God save the United States of America, the state of Florida, and the Son of the Court.
Good morning and welcome to a session of the 5th District Court of Appeal. Let me introduce the panel. To my right and to your left is Judge Vincent G. Torby, and on the other side of me and on the other side of you is Judge Bruce W. Jacobus. We have we have 4 cases scheduled today. It looks like 2 criminal, 2 civil. Criminal cases get 15 minutes aside. Civil cases get 20 minutes aside. If the appellant would like to reserve time for rebuttal, if you'll let me know, I will try to put it on the clock so you'll see it, and I'll also try to give you a hand signal indicating that you're running out of time. If you have a personal communication device, please turn it to a silent position or turn it off. But let's not interrupt any of the persons arguing today in front of us. I think that covers all of the detailed material. Let's begin with Marcus Fields versus State of Florida.
May it please the Court, Counsel. Good morning. My name is Joe Camino. I represent the appellant Marcus Fields in this case. I would like to request 5 minutes for rebuttal. This appeal stems from a case out of the Hernando County District. Mr. Fields.
Let me ask you about the traverse. I haven't had a chance to look to see if there's anything more definitive in the record about this, but other than I looked at the traverse, and the traverse, it's unclear to me in the second paragraph what he actually said, because the quote, there's no quote, beginning quote. I'm talking about the part that says, could use some of those ... that his boys on the other end are craving them bitches. You see that?
Yes, Your Honor.
Is the could use within the quotes? I mean, did he actually say that, or do we know? Or
Judge, I do have knowledge from my recollection. I would, defer to the government on that specific as to their recollection or what their information is. But my understanding is this was one phone call out of hundreds.
Right, but did he say he could use some of these Skittles? Was that his language, or was that paraphrasing by the government in the traverse? Is what I want to know. If you don't know, I mean, I don't know is the honest answer.
I'd hate to rely on my recollection. I just recall that
the wiretap transcripts are not in the record, nor are the tapes, or are they?
No, Your Honor, not on Mr. Fields' case. No.
Okay, all right. Were you able to, even though it's not cited in the brief, were you able to anticipate that I might ask you about preservation?
Quite frankly,
were you able to anticipate that?
Judge, that wasn't really a focus of the appeal.
Right.
I felt that through that we were attacking the specific elements of the crime.
Well, here's the concern that I have. I know I gave you the case ahead of the oral argument, so you've looked at the Blow case, right?
Yes, Your Honor.
Here's the concern I have. The way you all have teed this up for our disposition, our issue, our legal issue, is whether there is sufficient evidence to go to the jury on conspiracy to traffic in MDMA, right?
Judge, I would agree, and I don't want to interrupt, but
no, I paused.
I would say that that's not just the one issue. That the issue is whether or not there was sufficient evidence. Not only, I'm not attacking whether or not there was sufficient evidence to make a trafficking or possession with intent to distribute. My specific argument in the lower court and to this court is that not only was there insufficient evidence of a conspiracy, but there was just no evidence whatsoever
to support any charge.
of specifically a conspiracy. If there's no conspiracy, there is no other criminal action.
Right.
So that's the
But
specific.
it seems like, I mean, I went through your brief pretty carefully. It seemed like the arguments, though, were directed to the charge that was in the information. And that only makes sense, because that's what you filed the C4 motion, directed to the charge.
It was a motion to dismiss the information, correct?
Correct.
Basically a criminal summary judgment, if you will. In other words, there's not enough evidence, if everything's true, to support the trafficking, conspiracy to traffic. And they traversed it, they filed the traverse. The trial judge said, well, I think there is, right? Correct? And that's what we're here on appeal. And then he pled to the lesser, right?
And we specifically fashioned the plea agreement to include a lesser included offense of conspiracy, because that was the issue. There was no evidence whatsoever that Mr. Fields.
I mean, if you had won the motion, in other words, if you'd won the motion to dismiss the information, the state could have filed an information alleging the lesser, correct, or something else.
No. Quite frankly, Judge, if there's no conspiracy.
No, I understand that, but I mean, looking at it, I mean, it's to me, I mean, the traverse on trafficking, I don't think they made it. It gets a little closer when you talk about possession, depending on what he said.
Yes.
I mean, I think that's a closer call, but I'm just trying to think the way it's set up legally. It doesn't look like it's a dispositive motion. In other words, that they could have filed an amended information of some kind, couldn't they?
No, because, and I've read the Blow case specifically. It's cited at 993 Southern 2nd 540, and then the case that essentially overrules that.
Well, it only overrules it on the jurisdiction issue. I mean, it doesn't overrule the issue of whether there's a preservation, right?
Right.
I mean, that Blow was a case where the government charged them with one offense. He filed a motion to dismiss directed to the charged offense. The motion was denied, but then they negotiated a plea to a lesser included offense, and the second district said you didn't preserve your issue. How does that distinguish from this?
It's very distinguishable in the sense that the lesser included offense to which Mr. Blow pled didn't include the essential element that they attacked. In the motion to dismiss, they attacked specifically in that case whether or not there was sufficient evidence as to whether or not the child was caged.
Right.
And then he pled specifically to a charge that didn't have the element of caged. So quite frankly, I agree with the decision there and your concern with that.
Here's where, it's very, to me, it's similar to this case in that the original charge was trafficking. So that goes to an amount, correct? In other words, an amount.
Yes.
Well, clearly you couldn't tell from what he said. He might have been buying 1 pill or 10 pills. In other words, so trafficking, I think, there's no, but if possession's different, I mean, then you don't have to worry about the amount. It's just any.
And Judge,
I don't know.
But Judge, let me make clear, maybe I didn't make it clear in my brief, what I'm specifically attacking in the motion to dismiss and in this argument to this court is whether or not a conspiracy existed.
You're saying there was no agreement to commit any crime?
You're saying he didn't agree to do anything. I mean,
crime.
I understand that.
How do you explain the traverse, which suggests that he could use some of those Skittles, that his boys at the other end are craving them bitches?
How do I explain that?
Yeah, I mean, doesn't that suggest conspiracy to you? That his boys at the other end?
Not under the case law. I think the case law, specifically in Ramirez, the 371 Southern 2nd 1063, the 3rd District Court of Appeals case, specifically requires that there be an agreement. Not just, I would submit that what this fact that's alleged in the traverse is stating an assertion of, well, I could use that. And if I could just address
that. It
that.
could be a question of fact as opposed to a question of law on possession. Not, I agree with you on trafficking, but on possession, where I could use some of those, which, I mean, the implication would be, yeah, I want to get some of those for my boys, I mean,
On the other end.
On the other end. But it doesn't say how much. I agree. I mean, so I think you would have won, or maybe the trial court should have dismissed the information on trafficking, but I'm not so sure about possession.
That's
And they
fine. And I'll take the possession all day, but what I say is, there's no conspiracy under
Well,
the law.
I understand what you're saying.
Right. And-
I just say,
Well, now, the government gets the benefit, though, of any inferences that a reasonable jury could draw
Yes,
from the
sir.
comments, right?
I will agree to that. However, I would say that there has to be sufficient, an assertion that's a material fact here in their traverse that provides sufficient evidence of an agreement for the
Well,
conspiracy.
Hold on. He says, gets into this conversation about the availability of the Skittles. He says his boys at the other end could use those Skittles. And the evidence then is that there was a seizure of a trafficking amount of Skittles from his possession.
No,
So,
his.
from the, yeah.
yeah.
But doesn't that at least add up to an inference that there was a conspiracy?
The analogy that I've come up with in this particular case is, suppose this was a conspiracy to commit murder charge. And there's a telephone call where 3 minutes into one phone call out of 300 phone calls on a wiretap, a person on the other end says, yeah, I could use that guy dead. Does that amount to an agreement that the two of those individuals had?
I don't know. Is that why we have juries?
Well, I think that's why we have judges, so we can...
I don't know about the could use. The could use, you know, like I was thinking about the bank robbery. Somebody says they're going to rob a bank, and the guy says, well, I could use some of that money. I don't think that's a conspiracy to commit bank robbery. But the troublesome part here for me is my boys on the other end. Can you not reasonably infer from that he was telling the trafficker that he wanted to procure some drugs so that he could give those drugs to whoever these boys were on the other end, that he's kind of a middleman?
Judge, if I could take just briefly to address that, I know
Sure.
that I'm running out of time. I would suggest to you that the case law that I've cited to, and even the government has cited to, in the Lewis case, and that's a Second District Court of Appeals case cited at 463 Southern 2nd, I believe 561. If you were to look at that case and compare it to...
That case is distinguishable, I'll grant you that. Don't waste any time distinguishing that
Okay.
case. Just try to address directly my question about whether or not a reasonable jury could infer that this guy was a middleman based upon his assertion that he could use the drugs to give to his boys on the other end.
In the context that is put in the traverse, of course I suggest no, but I rely on the way that the law is framed in Ramirez, in the sense that there has to be an agreement. Now, does he maybe want some Skittles, or get some to his friends? Maybe, but is that an
Doesn't the case
agreement?
law say, I mean, there doesn't have to be a formal agreement. In other words, they don't have to spell out all the terms and those kind of things, correct? I mean, it really depends on whether it's a law question or a fact question.
Well,
And this one seems to me like it's a fact question when you're on possession anyway.
but judges hear motions to dismiss and decide whether or not those material facts in a traverse that prove a prima facie case.
Right.
And if this court believes that someone saying, I could use some of that, then is it an express or an implied agreement that I was...
To buy some.
That I was...
Because my boys on the other end crave those bits. I mean, I don't know. I mean, it's close call.
And that's, I think, to go to a jury, there needs to be more, as delineated in the Lewis case. And in this case, there being a traverse that doesn't necessarily dispute anything that I put in the motion, that's another issue I want to address. But I believe he put some additional facts in here, and the question is whether or not those are additional material facts. And someone saying that I could use some without anything more, and you'll note that the traverse doesn't indicate that's the end of the conversation on the phone conversation. They don't just hang up the phone and that's it. I mean, there's additional. I don't want to go into anything that's not in the pleadings, but
Right.
but that's all the court
But
has
again,
in front of it.
The transcript of the phone conversation is not evidence, right? At the hearing. I mean, wait. It's just this traverse.
Yes.
Okay.
Saving the rest of your time for...
Yes, sir. Thank you.
You have a little under 2 minutes.
Thank you.
May it please the court, my name is Pam Kohler. I represent the state of Florida in this appeal. I'll address the preservation issue.
I don't know whether you can.
Right, and that's, to be honest, that's
Because
why I
you really
did
didn't
not.
raise it in your brief. It was
Well,
just raised by me, you know.
The state did not object to it below either, so I was kind of...
Well, they don't have to object to it below because it's a preservation issue, but you could have raised preservation here.
And it's got to be the first time in history that the
First
state- the Attorney General's office has not raised
Well-
conservation.
You could have raised it here. You see, the reason I started on this academic exercise is because of the way the briefs are framed, which attack the sufficiency of the proof on the trafficking charge. And if I write the opinion the way you lawyers have teed it up for me, what bearing is that going to have on what he pled to? If I say there wasn't enough for a conspiracy to traffic in MDMA, what's the trial judge do with that? Because he didn't plead to trafficking, he pled to possession.
Right, but they also talked about at the plea that you believe it's in your best interest, and that it's my understanding that for purposes of the plea, this is an agreed upon and stipulated lesser included offense of the facts, the overall facts, but they're just saying for purposes of the plea, not necessarily that they could have proven it at trial.
But you know, lawyers stipulate that something is, that there's been a issue on appeal preserved at pleas all the time, and, you know, we shoot them down on that regularly.
I understand you are not bound by that.
We're not bound by anything
Absolutely.
they have said.
And for me, when looking at it, the trafficking portion, clearly, whether or not we could prove something else other than trafficking. The conspiracy, I don't know if we could prove anything else other than a conspiracy in this case, to be honest.
Because he didn't possess it.
Really
Correct, and there was no buy, I mean, you know, you can prove a conspiracy by the fact that there is a sale or a buy, but we have nothing here but for the fact this guy's found to have a stack
Well,
of
and y'all
Skittles.
didn't really quote what he said. Is that true? I mean,
There's no quotation, there's no beginning.
there's no
quotation.
quotations around it. So that's someone's impression of what he said, or it's a summary of what he said, or what is it?
Well,
There's a quote around craving them bitches, but the rest of it, is that just, so it's someone thought he said?
This is what the state provided, that his boys on the other end are craving them bitches, that then the Mr. Walters talked about, oh, I've got really
I think
good quality stuff.
The important part is he could use some of those would be, but that's not a quote exactly, so it must have been said in some other way, and that's just what someone's
And what's
analysis of.
what's confusing is the three dots. If it's not a quote, why are there three dots?
Yeah,
Right,
It probably is a quote, they just didn't put the beginning quote.
right.
could be.
Well, we have to take it for what it says.
Correct. I mean, he did provide
Either one
some,
of these statements in isolation might not be enough, right? I mean, you know, like my bank robbery example, if I say I could use some of that money, that doesn't make me a conspirator, does it?
right.
But so here we got a statement that I could use some, and a statement that my boys on the other end part is kind of critical here, right?
Oh, absolutely. I mean, because that indicates it's not just one person or not just himself, that there's something else going on.
He's a middleman.
Correct. And of course, we also know in his other case that he was the driver during a drug deal. but-
It's thin. It's thin.
Oh, absolutely. I'm not, but I'd still say it's a prima facie case. That's all, we just barely have to prove a
Do you
prima facie
think that
case.
Lewis is your best case to support a thin charge like this?
I couldn't find anything closer than that.
Because Lewis is distinguishable.
Absolutely, but
Let me ask you, when you say it's thin, as to trafficking, you think it makes it as to trafficking?
yes, because in after the defendant
Don't you have to have
says,
an amount?
and they do, they have a stack,
You have to, but see, you have to make the other leap is that he was going to buy the whole stack.
which lo and behold, when this defendant's house was, not this defendant, but the guy he was talking to, his house was searched, he had a stack with
Well, I
him.
understand that, but I mean, I don't think you could, from what he said here, you could make the leap that he's going to buy the whole stack. I mean, he could buy any part of
He
it.
says some of those.
So, I mean, possession seems better to me than
Or to
trafficking.
sell or
Yeah, yeah.
It's got to
deliver,
buy,
or,
there's two, because there's boys, or plural.
right.
Yeah.
So, I mean, it's clear that there's more than one person, so that a stack would be more likely
Well, yeah.
than just
that's
one
a
or two
big leap
pills.
there, I think, in my mind.
But, yeah, clearly, we could prove something other than conspiracy to traffic, but the conspiracy part, I mean, because there was no purchase, delivery, nothing, that we definitely would have to at least establish a conspiracy in this case, as far as preservation. Yeah, I mean, and then the prosecutor provided some facts, basically explaining his facts at the hearing. You can orally traverse if there's no objection. But basically, the gist of the whole thing was that there's a conversation, and the defendant, on June 1st, and the defendant says that some of his boys on the under craving the bitches, the other guy says, well, I got really good stuff, and I got a stack of it, and then they find 10 days later a stack of it in Mr. Walters' home, so. And all we have to show is a prima facie case, or we barely have to show enough at this point. It's certainly not at the point of going to trial and a JOA, so.
Okay, thank you, counsel.
Thank you.
All right, you got a little under 2 minutes.
Thank you. Just briefly, I wanted to address whether or not this was a fact enough to go to a jury. Under the case law, when I cited to the Ramirez case.
Is that your best case?
I think so.
Okay. Well, I appreciate that.
But I think it's the best case regarding this particular scenario, just because it specifically addresses what's required for a conspiracy, and that's essentially what I'm attacking in the.
If your guy said, "I want a quarter of that stack so that I can deliver it to my customers," that would be enough, right? For conspiracy to possess this particular drug.
I think that you could get into, when the defendant gets into details, and specifically...
I want 10 of those so that I can deliver them to my customers.
And I think that
Is that enough?
I think so, sure. But I think...
Isn't that what he said?
Isn't
that what he said in kind of a vague and tricky fashion?
But that's the issue, is that the operative word in your hypothetical is that I want. I want these, and this is why. In this particular case, I don't think that it passes the test, because he just specifically, if the court agrees with what the state put in its traverse, which, as you indicated, wasn't quoted as being his exact statements, and it's not the total statement of what was said, it's not an agreement that he says...
You could have put all that into evidence, I guess, and, I mean, you kind of got... Were you the trial lawyer here?
Yes, sir.
You kind of got a little bit sandbagged because they came in and did a little switcheroo on the charges, but you seemed to go forward with it, and I mean, it could have been all flushed out a little bit better at the trial level. But I think we've got to conclude that since the traverse said that he said this, whether it's in quotes or not, that's what he said, right?
I'm out of time. Is it okay to respond?
You can answer the question.
Okay. Judge, I think that you could conclude that would be the response during that conversation, but that being the response to an individual saying that he has some Skittles or that he has something it doesn't show a prima facie case that he agreed to take number one and I just want real quickly.
Now you go
not real quick.
He didn't agree.
We understand your argument.
He didn't agree to commit a specific offense with this individual.
All right.
Thank you.
We understand your argument. Thank you for your argument.
Thank you.